Okay, so this is our last chapter for the class, and we'll also wrap up our discussion on employment law. Here we're going to look at a variety of federal statutes that protect us against different types of unlawful discrimination in the workplace. And each one of these statutes gives us yet another exception to that general rule of at-will employment. We'll talk about a few of those in this video, and then in the next video we'll save that just to discuss disability discrimination in particular. So first off, I mentioned a couple of chapters ago, a lot of these protections come about around during and slightly after the Civil Rights era. So the first one we'll look at here is the Equal Pay Act of 1963. This made it illegal to pay people different wages for doing the same jobs with the same skills under the same conditions based simply on their sex. Now it's sex discrimination. I said in my slide here that it's illegal to pay women different wages. It doesn't just apply to women, but that's really why it was passed, because women were facing pay discrimination and may still in today in some cases. But this act makes it illegal. So then we go on to the next year, 1964, we have the Civil Rights Act. Now we discussed the Civil Rights Act in the constitutional chapter, where we specifically talked about Title II, which prohibits discrimination in places of public accommodation, and we focused mostly on restaurants and hotels and how it prohibits discrimination based on race in those situations. That's Title II, if I remember correctly, and here we also have in the same act Title VII, which deals with the employment context and protects people of several different types of classifications from illegal discrimination. You see them there at the bottom of the slide: race, color, religion, sex, or national origin. And this prohibits discrimination in terms of not being hired because of one of these classifications, but also it could be other actions that are considered adverse employment actions, like not getting being demoted because of one of these things, not being considered for a promotion because of one of these things, and we could probably think of a few others. Now, it generally applies to employers of 15 or more employees, employment agencies and labor unions, and also in the public sector. Now, so what that means, of course, is that if you only employ 3 people, this won't apply to you as a private employer. But depending on what state you're in, states have their own protections and at the state level, and there's a few other issues that you could run into. So I wouldn't recommend discriminating just because you don't think this particular section of law applies to you. There's a lot of different issues that can come up in the employment context when you take adverse action against somebody, but just this specific portion, that is how and when this kicks in and applies. So we got race, color, national origin, religion, and sex-based discrimination. Race, of course, it covers all races, and so-called reverse discrimination, where somebody's being favored, a particular race is being favored over others instead of punished, so to speak, for their race. That can be illegal too, unless it's part of a bona fide affirmative action program, which basically entails, a program that seeks to diversify a workforce or a student body in the case of schools, where race may be one component of many that are considered towards achieving an aim that isn't just about discrimination. It's about something primarily diversifying a workforce which has a value independent of race by itself. But generally, again, applies to all races. Also applies to skin color. So within a race, the shade of skin color. So it could be one person of discriminating against somebody else of the same race because their skin is either darker or lighter than theirs. National origin, of course, where you're from or where your ancestors are from, if you're have a certain heritage, or if you moved here from another country recently. And then religion, what's important to know about religion is that it covers all aspects of religious observance. And so there's many different occasions under different religions where part of the religion requires you to not work or not work on a particular holiday. And this law covers all aspects of religious observance, including those. It also covers religions that are minor religions, trying to think of a better, more obscure religions. It doesn't have to be, one of the popular ones like Christianity, Judaism, Islam, Hinduism. It could be a very, very small sect of people that have, a 20-person church that has a doctrine that doesn't really exist anywhere else. The question for courts is not so much that, but it's more, are these beliefs sincerely held, even if they're obscure and seem very bizarre and are rarely found throughout the world, as long as they are sincerely held beliefs and the evidence leads us to that conclusion, then they're protected as well. So all aspects of religious observance and all types of religion, employers have to make, under Title VII, reasonable accommodations to allow them to practice that religion. One of the tough ones, again, is when somebody wants to take off work, or somebody says, I can't work on Saturdays because that's when we observe the Sabbath, or things like that. You have to make those accommodations unless you can show that it would cause an undue hardship in running the business. And we're not going to go into how all those that goes into those cases. It can be, there's a lot of different things that can come up when you're trying to show an undue hardship. But basically, it's something that we wouldn't expect. It wouldn't be reasonable to expect a business to have to accommodate when it would sort of impair the business and prevent it from operating and functioning normally. Lastly, we have sex-based discrimination. Now, by the language of Title VII, it does not include sexual orientation, gender identity, because gender and sex are distinct concepts, and Title VII does not mention gender, or sexual orientation and gender identity primarily are not actually listed in Title VII. But recently, the momentum has been towards including it as not saying that gender identity is in Title VII or sexual orientation is in Title VII, but that sex-based discrimination, or those types of discrimination, are essentially sex-based discrimination because they don't conform. The people are being discriminated against because they're not conforming to sex-based stereotypes. So if you're discriminating against someone because they're gay, it's because a man is attracted to other men, and you wouldn't have a problem with that except for his sex, except for the fact that he is a man, because you don't have a problem with, in that case, when women are attracted to other men. So the logic is there that it is essentially sex-based discrimination. Now, the Supreme Court has not specifically said sexual orientation is included. There have been some courts, like the Sixth Circuit a few years ago, and other courts throughout the country who have expressly extended this concept of sex-based discrimination to include discrimination against people for gender identity, transgender people, sexual orientation. And so because of that, the EEOC, where you're going to be bringing these claims, the Equal Employment Opportunity Commission, on their website now says, it didn't a few years ago, but it now says, we interpret it this way. So even if you're in a state where your state still takes the opposite view, the EEOC is going to be on your side if you bring this case. And of course, the case is under federal law, not state law. Okay, so moving through this some more, there's also the Pregnancy Discrimination Act, which, of course, protects people from being discriminated against based on the issues related to pregnancy. And then next, we're going to go into talk about sexual harassment as a form of sex-based discrimination. Sex-based discrimination, like the other categories, can come in very direct forms, where this would rarely happen, I'm sure, um, but you're just told, you're not going to be hired because you're a woman. All right, it's usually not going to be that simple. There may be people who do it, but they're probably not going to tell you that. So that's a way that it can come about very directly, but it can also come about as a as a pattern of behavior that leads to you not being actually fired, but you're constructively discharged from your job because the sexual harassment is so severe or pervasive that we wouldn't expect a person to stay in that job. So even though you may leave the job, even though you weren't technically fired, and we consider that a constructive discharge if it meets the elements of this kind of claim. And it's similar to in landlord-tenant law, where you're not, your landlord doesn't actually evict you. They don't tell you that you're evicted, but they refuse to repair things in the place that leaves it in such an uninhabitable condition that we consider you to have been constructively evicted, because any reasonable person would have to leave themselves. Even though they took it upon themselves, we still consider it the landlord's fault that you were evicted, or that you were essentially evicted because it was the landlord's fault. So this is a very famous case. This is the seminal case on this concept of what we call a hostile work environment, where, again, you're not fired from your job, you're not necessarily even demoted, but the harassment is so severe that we wouldn't expect you to be able to stay there and put up with it. It's somewhat similar to, if you remember, intentional infliction of emotional distress. It's somewhat similar to that. It's not the exact same thing, but it's just this idea that it's behavior that is so outrageous that we wouldn't expect anyone to tolerate it. So Harris versus Forklift Systems. This is about Teresa Harris. I'll just take you through the facts here. And let me mention too, this idea of sexual harassment as leading to a sort of constructive discharge where you have to get out. It can be just one event. So if it's severe enough, so if your boss actually attacked you and sexually assaulted you, you don't have to wait for that to happen half a dozen times. That's enough, of course, for any reasonable person to feel that they can't go back to work. Even though you weren't fired or demoted, you've been constructively discharged because nobody could go back to that situation. But it can also come about from many events over the course of time, maybe even years, that adds up to such a pervasively harassing environment that we wouldn't expect anyone to put up with it. And that's what happens in this case. So Teresa Harris is a rental manager, and her boss is Charles Hardy. So here's the things he does, among others. He insults her in front of other people. He makes sexual suggestions to her and other people. One quote from the case was, she made a comment and he said, "You're a woman, what do you know?" Evidencing clearly that he's questioning her intellect simply because of her sex. He called her at one point a, quote, dumbass woman. He suggested they, quote, go to the Holiday Inn to negotiate her raise. She closed a deal or accomplished something at work, and he said, quote, "What did you do?" Promised the guy sex Saturday night. He asked other women in the office to collect coins from his front pants pocket. This is really ridiculous stuff. He throws things on the ground sometimes and asks female employees, to pick them up so he can watch them bend over. He makes sexual comments about their clothing. So eventually she quits because she can't take it anymore, and for obvious reasons, and she sues. She wins this case, and she loses in the lower courts, but this ultimately made it to the Supreme Court, and they reversed the lower court's decision. And there's a quote here from that decision. You see, employees' psychological well-being is relevant to determine if the environment is abusive and has a discouraging effect on the employees staying on the job. So like those intentional infliction claims, you may be talking to a professional counselor or psychologist about how it's affected you, your mental well-being. So it's more than just, and I think when these cases first started, and it may have been when this case came out, there was a lot of employers were thinking, it was there might have been an overreaction a little bit on some employers where it was like, if anybody said anything wrong, they were going to get bankrupted by some lawsuit. But as you can see from this case, it's not because somebody makes one off-color joke. And you'll see, even if somebody does do something bad, the employer can take care of it by simply addressing it. And we'll talk about that. We'll talk about vicarious liability. But it's not just that somebody makes one joke or somebody flirts once with a coworker or something like that. And again, it can be one event, but it's going to be something. If it's going to be one event, it's going to be something really, really severe, and not just maybe one insult or one again, off-color joke. This is a situation where you've got repeated behavior that occurs pretty much every day, and it's clear that it only applies to women. He says it's about women very clearly, and we wouldn't expect Ms. Harris or any woman to deal with this on a constant basis. Okay, so moving into some more statutes, the Age Discrimination in Employment Act covers discrimination based on age, but it only deals with people being discriminated against who are older. So it only applies to people over 40 years. It's all about protecting people from being pushed out of jobs just because a younger person comes along and they think you only have so many years till retirement, and they think they can get more out of this employee. So it protects that kind of discrimination. Then the Uniformed Services Employment and Reemployment Rights. This is discrimination based on military service. And then you also have the Genetic Information Non-Discrimination Act. Protects people from being discriminated against because of their genetic information. All right, so how do we bring about these claims? This is an important concept because there are other cases where this is the situation as well, where before you can bring a lawsuit, you have to do what's called exhausting administrative remedies. If a statute provides an administrative way for you to go about handling the claim by bringing it to a government office instead of a court at first, then generally you have to go through that process and exhaust it or do everything you can before you will be allowed to sue in a regular court of law. And so that's true with these discrimination claims. You file it with the Equal Employment Opportunity Commission or the EEOC or your state's equivalent. Every state has basically a state employment agency that handles these claims as well. So also that's what's important about this is there's a time frame in which you have to file the claim when you knew of the claim or you should have known that you had a claim based on discrimination. And with the EEOC, if you choose to bring it there instead of to your state's office, it's 180 days, and different states have their own timelines for their own state offices. In South Carolina, I believe it's still 300 days. So you have a little bit longer here to bring the claim. But in both cases, it's much shorter than what a typical statute of limitations would probably be. In South Carolina, and I think even North Carolina, up north of us, for most of the lawsuits you would bring against a person or business, you have 3 years to bring it. So 3 years as opposed to 180 days means for these you have to decide much quicker whether to go through with the case than you do with other types of litigation. So the EEOC will investigate. They'll ask for both sides of the story from the employer and the employee. They might try to get you to mediate to come to some sort of settlement, especially if they think discrimination has occurred or it seems at least like there's some good evidence or that the case could drag out. You want to try to mediate and come to some sort of agreement. And if you don't wrap it up with the EEOC, the case is going to continue until they close their investigation. And you generally have to wait for that process to conclude before you can sue. And when they close the case, whatever they decide, you'll get a letter that says, it's called a right to sue letter, and it says you now have a right to sue if you want to take it to court, because we've concluded. So you generally wait for that process to be over. But you can also, once 180 days have passed, you can request a letter early if you want to, but that means, assuming they haven't closed their case yet, and they're required to give you a letter after that time frame. But that means they're going to stop their investigation, and once they give you that letter, and so then you've got to leave the EEOC process and go to court. Other forms of discrimination, talked about harassment and constructive discharge. There's also disparate treatment. And this is, we'll talk about something called disparate impact in a second, but this is where it's not one person who's targeted for a protected classification like race or sex, but it's the whole group, and there's some intentional policies that has the effect of discriminating against say African Americans, for instance. So you see the elements there. Again, you have to belong to a protected class, show that you're otherwise qualified for the job, because if you're not qualified for the job, otherwise none of this really matters, because you can't get a job as a lawyer if you're not qualified to be a lawyer, obviously, regardless of this law. Okay, so let's go back a little bit and go back to what I was saying about kind of stopping these problems before they cause the employer to incur liability, where say you have some harassment going on based on race, based on sex, based on one of these classifications. Remember, the employer, for damages, injuries you cause or that your employees cause to other people, your employer is generally vicariously liable when they occur on the job. And the way to avoid that here is, in the case of harassment, is to put an end to it and rectify the situation before it's risen to the level of constructive discharge. So before a reasonable person would feel like they have to quit their job, you can protect yourself from liability as the employer by having a process for reporting these issues and for effectively and efficiently resolving them and managing them. So if somebody's really being severely harassed, that person needs to know who to go to in the business. They need to be able to open up the policies and say, this is what's prohibited, here's who you go to talk about it. And if it's really severe harassment, the resolution might be that person is immediately fired, in which case the victim is not constructively discharged. They shouldn't feel like they need to leave because the employer has stuck up for them. And you can imagine a bunch of different complaints somebody might have, and it's not going to be a problem probably in most cases, as long as the employer has a way, again, to report them and have them effectively handled. And another thing, a side note, is that in your policies you want to have some rules about inter-office dating. It's kind of hard to stop people from, forming personal relationships when they work with people they see every day. But you can have rules about when that should be disclosed to HR to avoid any sort of he said, she said events later on if the relationship goes bad. Another form of discrimination takes the form of disparate impact claims. Unlike disparate treatment, this conduct is not intentional. It's something that it wasn't done to discriminate against one group of people, but it has the effect of doing that. And we'll look at a case here where that happens. So again, it's unintentional. The rules or the policies favor one group over another in a protected class. Again, race, sex, national origin, religion. And then a question of, are they justified by legitimate business goals? And with a lot of these, if there is something that this can be a defense to a lot of these cases where whatever's happening is there's a legitimate business interest, or the business can't function without doing what's being done. In the case of harassment, that doesn't really apply because there's no legitimate business reason for that. But you'll see how it comes up with disability discrimination. You can't accommodate a certain disability because it would render the person unable to do the job, or the business otherwise to function. So this is a disparate impact case, EEOC versus Dial Corporation. This involves a what they call a work tolerance screening test that was designed to test people's strength abilities when it comes to doing some physical labor at this sausage plant. Now, this test did not always exist. It was introduced sometime later, and before it was introduced, the workforce was about 50-50 men and women. After it was introduced, the number of women that were hired for the job dropped to 15%. So this was a way of screening people to see if they could do the job. This was really all about lifting packages of sausage, 35 pounds worth of sausage. And the strength test, the problem with it was that it was much harder than was necessary. It required a much higher demonstration of upper body strength. And so the men were, had the effect of favoring the males who were doing this test. And so as a result, you had quite a drastic drop in the women who were hired to do the test. And the reason Dial lost this case, again, is it wasn't a necessity to the business. It wasn't even really a necessity to this particular job, because they were asking them to do not only a tougher test, but as you see here, they were asked to perform 4 times as many lifts as the current employees, the people who were interviewing for the job, were doing. And they also weren't given any rest breaks. So that had the result of having a disparate impact based on the sex of the people applying for this particular job. I'll just close here in this video with just a note again about some of these defenses to the statute. When there's a business necessity like experience and skill requirements, obviously you can develop ability test, like in the Dial case. You can do those as long as they don't have a disparate impact or are discriminatory towards one of these protected classes under Title VII. And then also bona fide occupational qualification. If what you're having to accommodate for is a bona fide part of that particular job, that, in other words, if you made the accommodation, the person simply wouldn't be doing the job that they were hired for. So, for instance, if your religion says you can't work on Saturday, but you're applying for a job that is specifically you only work on Saturday, it's a part-time job maybe, then you can't make that accommodation, because that's the whole job. So if it nullifies the person from working, or it just nullifies one of the key components to the job, then that can be a defense to these cases. There have been a couple of cases. I remember one in Disney World based on religious discrimination, where I think somebody was hired. It was a Muslim woman who was hired to play a character in the park, and she wanted to wear her religious head garb at the job because it was part of her religion. Now, normally that's something you would accommodate. In this case, though, I think she was supposed to dress up as a character, for which that did not fit in with the costume. That was the whole reason she's hired. And I don't remember how that case played out. I think they might have settled it because they probably could have just moved her someplace else or given her an equivalent job with, similar responsibilities and similar pay. But you can kind of see how this could play out in a number of different ways. Where somebody wants an accommodation, but it's hard to give it to them without rendering the job basically useless. So that's where we'll leave it for this chapter, and then in the second one, again, we'll come back and talk about disability discrimination.